Good evening, respected insolvency professionals, distinguished guests, and dear friends. I am Namrata Randheri from IPNet, and it is my great pleasure to welcome you all to today's webinar on discussions on FAQs on IBC issued by IBBI dated 24th September 2025. We are honored to have with us remarkable expert Mr. Jitendra Lohia, sir, who is an IP, BCom, FCA, and a CISA. Sir, your presence here adds immense value to our learning community. This is the 57th webinar in our series under IPNet, our platform dedicated to strengthening our professional capability and well-being through shared knowledge. Without further delay, I invite Mr. Sandeep Singh, member of IPNet East, to deliver our welcome address. Sandeep, sir, over to you.
Thank you, madam, for welcoming me. This wonderful occasion of IBNet session. Good evening, everyone. It gives me great pleasure to welcome you to the 57th edition of IPNet webinar on the theme discussion on FAQ on IBC issued by IBBI dated 24th of September 2025. We are honored to have our eminent speaker with us, Mr. Jitendra Lohia, who is an IP, FCA, BCom, and a special note of thanks to Sri Ashish Makhija, sir, President of IPNet, whose vision and leadership have played a pivotal role in building this vibrant, growing community. For those who are not yet members of IPNet, this is a great opportunity to join us. The membership link has been posted in the chat. We sincerely look forward to welcoming you into our family. Over the years, IPNet has evolved into a powerful knowledge-sharing platform for insolvency professionals across India with a mission to provide expert-led webinars, study circle, and practical workshops, offer hands-on guidance for navigating complex IBC issues, and maintain an exclusive digital portal with curated resources, updates, and member support. To our existing member, thank you for your ongoing trust and active participation. To everyone joining us for the first time, a very warm welcome. We encourage you to make full use of the opportunities and benefits that IBNet offers. Thank you for being here this evening. Let us begin what promises us to be an insightful and thought-provoking session. Now I would like to talk about our eminent speaker, Mr. Jitendra Lohia, who is an FCA, CISA insolvency professional and BCom honors. Mr. Jitendra Lohia has a distinguished career of 22 years post-qualification experience as a partner in KN Jain and Company, chartered accountancy firm with branch and network locations spread across India. Director in class insolvency professional entity registered with IBBI. Currently acting as a resolution professional and liquidator in many insolvency cases and have also resolved many cases both as a resolution professional and while acting as an advisor and support service, including one leading manufacturer of equipments being McNary Shiaji Engineering Limited, having 4 running units across and resolved as a going concern. Regularity representing corporate data, creators, and resolution applicants before various branches of NCLT. Over the years, have been practicing in varied fields, including SEBI laws, corporate restructuring, mergers and acquisition, bank audits, CAG and government audit, legal audit, KYC related services, consulting related NBFC and MFI institution. Income tax laws, tax audit, transfer pricing, audit, tax, GST, tax planning, accounting principles, Indian GAAP and IFRS, various audits like statutory audit, limited review audit, internal audit, VAT audit, event audit, internal audit, budgeting preparation of various SOPs, and treasury management. Apart from the above, is also providing management consulting, business development, and assessment of NBFC and transformation of NGO MFIs to NBFC. Served as a fund manager of Innovative Challenge Fund under Kolkata Urban Services for Poor, managed by Department of Municipal Affairs, Government of West Bengal.
Incoming voice call from +9189613333.
Was also consultant to Director of Town Planning and ULBSC Government of Arunachal Pradesh for implementation of double entry accounting. Was consultant to PACS or DFID and Christian Aid funded project implemented by a consortium named as PACS led by CRTS India for audit and monitoring and National Agriculture Innovation Project under West Bengal University of Animal and Fishery Science for formation of a producer company. He also served as the president of Association of Corporate Advisors and Executives, that is SCAE, one of the largest professional body in Eastern India, and has served as a convener, secretary, and treasurer of ACAE Study Circle. He was also president of Lions Clubs of Calcutta, one of the largest Lions Club in India. Contributed
Incoming
papers
voice
and
call from
articles to various seminars and symptoms, and was also editor of the prestigious House Journal published by ACAE for 2 years. He also contributed as a speaker in seminar and workshop organized by professional bodies and various affiliates of Institute of Chartered Accountants of India on the varied topics, including on IBC. I think that's done. I'm done with my welcome address. Over to you, Namrata madam.
I think you are mute, Namrata ji.
Oh. Yes, sir. Thank you so much for this insightful welcome address. Now I shall play the video that showcases IPNet's purpose, initiatives, and contributions.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you for watching. Now to introduce our moderator for this evening, who's Mr. Binay Singhania, who's a CA and IP, and our moderator for today's session, and also an IPNet member of East, to deliberate and kindly give us his welcome address, sir.
Yeah, good afternoon, friends. I'm delighted to have member of this IPNet, and I am fully aware of that everyone whoever is working as IP or with the IBC, both as a lawyer or as an insolvency professional, everyone is aware of Ashish Makija sir and his contribution to the IBC, IP growth itself, and the good initiative taken by him for IPNet and is giving so much time for this association is really remarkable. As regards to this webinar is concerned, it's a very well required one. It was the FAQ was issued only on 25th of September, and whatever questions were actually there in the minds of the insolvency professionals, almost all the questions have been given reply to that one. Most of the questions have been given. Most of the questions have been replied very well in the FAQ. Out of the 88 questions, uh, I think most of the questions were raised in each and every CRP cases. Certain matters were there which were not resolved. As regards one of the question which has been mentioned here, Mr. Loya will be deliberating of the 19.2. Section 19.2, we are not getting any support from the promoters, and it has been mentioned here that if we are not getting any support from the promoter, and he's also not appearing or is not giving any documents in this regard, we as RP or IRP should approach the NCLT and get a non-bearable warrant against the director. So I'm not aware of whether this non-bailable issue of non-bailable warranty is there in the court or not. Because we have faced, means I think almost every one of us have faced non-cooperation from the promoters. And I think a few orders are also there from the NCLT that promoters should help the RP and support the RP by providing the document. And if the promoter is not cooperating, then also with all those remarks, the order has been passed. So it has to be seen how can we go ahead in this matter. I think Mr. Loya is already there, and he will be giving a brief of that one, including all the other questions. So I am handing it over to Mr. Loya.
Uh, thank you, Binayji. Binayji is my good friend, and thank you, IPNet, for inviting me into this platform and enabling me to share the thoughts on the recent FAQs issued by the IBBI. We always have a complaint with the IBBI that कि हम लोग जब मेल लिखते हैं तो कोई रिस्पॉन्स नहीं आता है. Whatever the query we raise, you see, I hope IBBI officers are not here. But yes, but हम लोग कभी भी we raise a query, we raise that how particular matter will be dealt, so we never get a response. And this is the first time wherein the IBBI has issued a FAQ and in the right direction, right? Because we have many queries. Some of the queries get resolved through the judgments. There are basically a contradicting judgment of many issues which arise during the CRP process. But still, FAQ from the IBBI at least ensure that if we act as per the FAQ, we cannot face further, disciplinary actions or action by the regulator if we act according to the FAQ. And these FAQ, if you go through it, it is about the CRP process, it is about the liquidation process, it is about the voluntary liquidation process, and how do you deal with the situation. It covers most of the, situation we face while conducting our assignment. So with this, thank you again for having me here. I'll try to, jointly along with you, go through the FAQs. These FAQs are in a simple English language terms, but yes, jointly reading the same will give us more meaningful apprehension of the FAQs and condition we face during the CRP. So let me share the FAQ on the screen, and while we discuss on the FAQs. Okay. So I think the screen is visible. We go to the first.
Yes.
Yes, sir.
So, as you can see, and as Vinayji has already told, the our most of the problems arises from the fact that there is a non-cooperation by the director of the suspended board. So 19.2, as he referred, there were some changes in the law relating to Regulation 3A, which was brought in for joint control and custody to be taken immediately after the commencement of the CIRP. And Vinayji mentioned about the arrest warrant. The RP can resort to the issuance of non-bailable arrest warrant against the director who are not cooperating or even not appearing. In one of my cases, I got it issued from the NCLT, the non-bailable warrant. But yes, I mean, to my disappointment, even after repeated issuance of the non-bailable warrant directly to the police by the court, we could not get the director present in the hearing. So forget about the cooperation. So that company has gone into liquidation, but still, yes, there is an option. Not every case will meet the same fate. So let us start with the FAQs, which has been, if you can go on reading along with me also, that will be helpful for understanding what are the comments which has been collated by the comments or through the discussion paper floated by the IBBI. So now, often a time we face a situation where the CIP order is not communicated, right? Directly we are appointed from the panel. So we don't know whether, I mean, there are cases where the appointment has been done by the financial creditor with my consent. So we generally try to chase those cases that when these orders are pronounced and all, then we are aware of the orders being available in the website or uploaded in the website. So there are two situations where the upload happens, you see, after a few days, 5 days, 7 days, or maybe you are not communicated. The orders are uploaded immediately. You are communicated either by the financial creditor or by the registry after a few days. So in such situation, what should be the insolvency commencement date, right? So the FAQ clearly says insolvency commencement date, irrespective of when you receive the order, does not changes. It would be remain same as on calculated from the date of announcement of the order, not when you receive it. It further says that if required, you can take exclusion from for the particular period for delay in communication of the order, but for mentioning in the publication for the closure of the CIRP period, you have to consider the date as the announcement date as the CIRP initiation date. There is no ambiguity on that. I hope most of us were doing this, but yes, in ambiguity. And you make it evidently clear. Additionally, I am sharing it from my experience. You make it evidently clear that if you know that the order has been pronounced and not uploaded, just try to mail it to the registry. Although if you go to the NCLT website filing site, there is an option where you can see that when the order has been uploaded in the portal. So you can take a screenshot, but yes, it will be there. Just for the purpose that you can respond to any further investigation, any inspection by the regulators, right? Now, relating to the second FAQ, which is regarding the public announcement. Now, public announcement is required to be made in both English and vernacular papers. We most of us were having a confusion whether the language used in the vernacular paper should be English or in the regional language. Now it makes FAQ make it very clear it should be in the regional language only. Now it's very, you see, logical also that if you publish a public announcement in English in a vernacular language, the purpose of this publication is that the public who are not concerned with English may read the publication in the language which they understand. So not only for this, everywhere where this requirement is there, we should follow this process for publication in the vernacular papers, unless otherwise it is allowed under that law. Now, suppose in the third FAQ, it says if we are not able to know that where the operation of the CD is being carried on prior to the CIRP commencement date or its registered office where it is located. Registered office, we can find it out as per the MCA portal. But the operation, the major operation which is being carried out, or the corporate office, we might not know initially when the CIRP is admitted, even in the balance sheets and all. So it says that you can publish in the location where its other offices are situated subsequently also, whenever you come to know. But the initial publication must be done within 3 days in the location where the registered office is situated, or all the known location. Now, suppose I'm based out of West Bengal, so it should be published in, you see the company is based out in West Bengal. It should be published in West Bengal also. If it is having any offices in Jharkhand, so it should also be published as per the financial statement or whatever record you have based on the public domain, or if the suspended board has communicated to you about the location of its business. But no worries, even if you fail to make a public announcement in the other business places, you can do it afterward whenever you come to know of that. It's not that if you missed it, you cannot do it once again. You do it once again. So then, in absence of the books of account, it is difficult for the RP to admit the claim and constitute the COC. How should the RP proceed in such cases? Right? Now, the verification of the claim clearly specifies a claim can be verified based on the claim submitted by the claimant. It is not mandatory that you verify it from the corporate data, but yes, you have to see whether the documents given by the claimant is supporting the claim which he has submitted. Right. You must also try to get the information if the board is not cooperating from the MCA record of charges, income tax, GST portal, EPF to admit the claim. And when you admit a claim, maybe even provisionally, you must update the information as and when further information are received. So if information is not there, the cooperation is not there, you cannot wait. You have to do your duty within the defined timeline. If you can admit it, say you can admit it. If based on the document provided by the claimant, you cannot admit it, you must communicate that you cannot admit it. Your claim is not viable, liable to be admitted or rejected, whatever may be. Right. So waiting until the decision of 19.2 petition for seeking books of account and or not before constituting the COC. Right. So the FAQ says RP must constitute the COC based on the specified timeline and not wait for the order under section 19.2. And if you have filed the application under section 19.2, not that you sit across and wait for the orders. You pursue it, you mention it before the court that it's very urgent. Right. But whatever happens, you have to take available records on consideration from the COC, constitute the COC, or admit or reject the claim, or keep it pending for verification. But the reason that books of account are not available cannot be a reason that you are not acting within the timeline. That is what the FAQ says. Yes.
Just for the sake of clarity, ऐसा कई बार होता है कि भाई the company is not working for last 10 years, 5 years or so, and the books of accounts are not available. But when we issue the public announcement, we receive claims of many persons as an employee, claiming to be employee. Certain people provide the salary slip for 2-3 months, and certain people do not provide any salary slip also. तो उन केसेस में मान लीजिए हमारे पास में 100 एम्प्लॉय का क्लेम आ गया, उसमें 5 आदमी ने तो सैलरी सर्टिफिकेट, सैलरी का कोई स्लिप दे दिया है, 95 people do not provide any salary slip. So should I keep it for pending for verification? Should I take it as claim or what?
No, you see, I mean, if I would have to act on such a situation, what I would do is I will verify the document provided by the claimant. Now, if there is a salary certificate, pay slip, if something can be deduced out of the bank statement, I would admit the claim to that extent. Now, if certain worker or an employee has not submitted anything, just submitted a claim form, I must not admit it based only on the claim form. There must be a supporting document. You must keep it, you see, pending for verification. There is an ample reason. You see, if you cannot verify even from the document of the claimant, and claimant doesn't have a document to prove his claim, so how, as a RP, can we admit the claim? Your books of record of the corporate debtor also does not justify any outstanding relating to that particular. You can get a record from the EFO, EPFO, from the ESI. Now, if their last drawn salary is of that particular amount, you have to first establish whether he is actually an employee of the company or not. That is a primary requirement. And then satisfy about whether that amount could be outstanding or not. But unless you do it simply that the worker or employee has submitted a claim, I think we must not admit it blindly, because that claim, once admitted, becomes a liability on the corporate debtor also, even if it is a wrong claim. We have seen many cases where wrong claims are being furnished. Right? So now the FAQ further says that if there is a Section 12A withdrawal application filed before AA, before constitution of the COC, and said petition is pending for hearing, whether RP must constitute the COC or wait till 12A orders. So the FAQ clearly says if there is no stay on the constitution of the COC, there is no appeal before the NCLAT, and Section 12A application is pending before the adjudicating authority, the RP shall continue to work for the CIRP, including constitution of the COC. The process cannot be stopped or modified later, depending on the outcome of the such application. The application might be rejected in certain scenario. So you have to work as if nothing has happened till there is an order by the adjudicating authority. Whether Form 2 and 3, basically this is filing relating to to be filed with the IPA. When the RP is not appointed as an IRP, is not appointed as an RP with 66% of vote, and no decision is being taken, right? And you deem to become the RP by default after 40 days from the CIRP commencement. So RP has to file the requisite form as an RP saying that he is a deemed RP, and perform all the function of the RP till he is replaced or confirmed as an RP after 40 days. Right? Now, when the liquidation order is pronounced by the AA, then how and up to what date Form 2 and 3 to be filed by the IP with the IPA by the IRP who is continuing as an RP. So it is very clear, I think we all are clear on this, that it is to be filed within 7 days of demitting the office. That is from the date when the order is pronounced. So when the order is pronounced, that is the date when the liquidation commences. Now, the FAQ number 9 is the same as for the constitution, whether if it is not, if the IRP is not confirmed as an RP, or the agendas are simply deferred. So in such situation, he continued to work as an RP on after 40 days as a deemed RP, as per the regulation within the timelines. Irrespective of that, the agenda is not placed or deferred or not approved. Can the IRP appointed from the panel by the IBBI can be replaced by the COC? We all know that yes, it can be replaced by the COC with requisite 66% of voting. Regarding the claim, as we all understand, the claim has to be filed within 14 days initially from the date of publication, and then a claim can be accepted within 90 days, right? As per Regulation 12. Now, if you receive a claim after 90 days, should you reject it? Or if there is an order by the court, how do you deal with such order? Right? So are you duty bound to reject a claim after submitted after 90 days? For this, you have to refer to Regulation 13, which says that verification of claim received after 90 days, the FAQ says. So all the claim up to 7 days before which the resolution for approval of the resolution plan is being considered shall be verified and for accepted for collation and placed before the COC as acceptable or non-acceptable. Now COC may take the decision on all such belated claim, and now with the change of the regulation, it is the RP who would file an application for condonation of delay in filing of claim beyond 90 days. Based on the decision taken by the COC after his decision on acceptable for collation or non-acceptable for collation, and its treatment in the resolution plan. Right? Some claims which are submitted are subject to the litigation of the CD. There is a long-known litigation, say for example, GST, income tax, or even you see the FCs and all. So there are litigation which are pending at NCLT, NCLAT, SC. Claims are partially admitted, partially rejected, or fully rejected. So how do the RP deal with all such claims? It says that the information memorandum should provide all contingent claim also. The regulation 41, if you see that, right? If it is not precise, estimate can be given. And the treatment to such claim till the outcome shall continue till there is an order by the adjudicating authority or any forum or any court. And if there is an order, the RP has to act on the basis of the order in almost all the cases. Now, if there are no claims which has been received after the public announcement, so the regulation 6A now mandates the RP to send communication to all the known creditors, whatever is available from the books of record, MCA record, whatever, wherever is there, through post, through emails, right? He can seek information from NSCL of any creditors. Now, even if after all this exercise, the RP is not receiving any claim, he may submit information to AA where no claim is received for further advice or further posts to be followed. Now, even if the IRP or RP sends some communication to the creditor and the claimant does not file a claim even after that. So regulation 6A provides that you are required to send a communication. So what should you do? The FAQ says that if you have done your known endeavor in communicating the CIRP process to all the known creditors, available creditors, so you can simply detail the same in the information memorandum that these are the creditors. Now, nothing has to be done from your end. If you have taken all the steps, what is required to be done? Now, the books are not updated. The claimant's amount is the amount, or the claim document is not sufficient. The CD books are not. So claim can be admitted based on the supporting document of the claimant also. However, we should check whether the documents are validly provided or it's are valid or not. There should be an effort to reconcile, revise, or update the books of account after taking into consideration such claims, or update the claim based on the further information available. There are some cases of the claim where the banks are charging penal interest or default rate of interest as per their card rate, which at time we feel are very high, maybe 2% per month or 4% per month. So should the RP consider such high interest while verifying the claims? FAQ says that if there is a financial institution claim such as bank, as defined under the code, or regulated entities claim, and they are charging interest as per the institution applicable loan document and norms. So these claims can be accepted for admission, even if they are unreasonable or high. However, for unregulated financial or operational creditor, RP may have to examine the transaction from the perspective of extortionate transaction also. Right. So yes, tell me.
Just before this FAQ, You were
Yes.
saying that if the claims are not received, that on the basis of the creditors shown in the balance sheet, you should include that in the IM. Now, what is
Yes.
the purpose of the IM if the COC is not being able to be constituted?
No. See, both discussions are separate. There is one reason that COC is not constituted. Now you have to, if you are not able to constitute the COC, not able to take the CRP forward. So there is no use of, when I'm saying that if there are 10 claims which are not being able to be collated, but there are other claims now which can be collated. So
No, but if there is no claim at all, then what will happen?
definitely you will not be able to proceed further in the CRP process. In that case, we discussed earlier in the FAQ, you must approach the adjudicating authority for further direction.
There cannot be any case where there is no claim. At least one applicant is there who has filed one petition.
No, Binay, there is there because the CD files section, you will come to the case where section 10 is filed by the CD himself. It gets admitted and there is no claim.
No, in case of section 10 also, the city is saying that there is a default in making payment. So the details of default has already been given. And the details of default means the person to whom the amount was payable and it was not paid. So it is there in the books. So there must be a claimant, but the claim is not filed. Claim filing is separate issue. Claim is there or not is a separate issue. So the claim is there, but the claim has been filed or not. So the claim is not filed due to the reasons that they don't want to contribute for the CRP court. That is the reason for not.
That is what I'm saying. Well, our discussion is that if there is no claim filed by the claimant, we cannot take it on board and we cannot constitute the COC unless the claimant himself filed the claim. We cannot, suo moto, take that claim to be admitted and continue with the CRP process. You are very right in that claimant in such situation does not want to come on board and contribute to the CRP expenditure. So in that case, you approach the CRP, you approach the adjudicating authority, that how do we take it forward? Adjudicating authority in such situation might reverse the CRP process or maybe call for the dissolution or other action that can be taken by the adjudicating authority. But nothing that you can do in such a situation, right? You can proceed only if there is a claim or if you can constitute a COC. If there is no COC, you cannot, as per the law, act on your own. Right? Hope I am clear. Now, regarding the PF department claim, the PF department are not filing a claim in the formats, in the requisite format, not providing the information. So the FAQ says that you simply cannot, you should not reject as per the judicial pronouncement based that the claim has not been provided in the format. You try to pursue them to submit the claim, but you should not reject it merely on the technical ground if the amount is actually payable. Now, this situation we also face if there are more than, one operation creditor having individual debt of 10%, or when all the operational creditor jointly having an outstanding debt of more than 10%. So should a notice of COC meeting should be sent to every such creditor? So FAQ says that all individual OC having 10% of more of the debt must be invited to the COC. And if no one is having more than 10% and the cumulative percentage is more than 10%, a representative may be invited, should be invited to participate in the COC meeting, which the OC nominates. It's not only about the individual OC that exceeding 10%. We have seen in many cases that we are not doing so. Now this FAQ makes it very clear, even if we must invite the representative, or maybe even you can take a view from the liquidation regulation that the highest OC can be invited to represent if there is no nominated representative in such cases.
One small doubt. Say if there are varied operational creditors who do not belong to a particular class or do not from a company, from a particular company or otherwise, then how do we invite
law does not discriminate or do not provide a sub-classification of the operational creditor. That is under 53. But you see, as per the regulation and the code, which talks about inviting OC having 10%, all OCs are placed under the same class. So it's not like a liquidation process wherein each class is defined. Here, the entire OC has to be taken as one, as an operational creditor, and then you have to act according to the law and provision.
Can we pick up the operation creditor who has got the highest claim among the operation creditors?
If no one is nominating anyone, then yes, you must do it and inform to all the other operation creditor that I have chosen this operation creditor with the highest amount due as the representative. Right? If you have any objection, you nominate. If you do not have any objection, so you continue. At least you have done what is required.
Yes.
Right? COC meeting, whether can be conducted on Sunday or holiday? Yes.
No.
Whether this
No.
IRP is required to do any step for nomination of or any representative of the OCs? I mean, whether any voting percentage or something like is required to be done by the IRP, or the creditors amongst them will do that exercise?
See, law is silent on this, but you must ensure that you see whatever the representation is done through a transparent process. You must ensure. I mean, now suppose a OC calls himself as a representative of the other OCs. So you cannot just simply induct him as a representative. You must do your background check, whether all the OCs has nominated him or not. Whether, you see, you can send an email simply to them. The method can be, any, maybe through a e-voting, maybe through a postal voting, maybe through an email. The law does not describe anything in this regard. But you must ensure if you are nominating or allowing a person to nominate a group of OC. Yes,
Can IRP take that action? Can IRP take that action by providing appointing a e-voting agency and providing a e-voting platform amongst the creditors?
I think generally you must avoid to do this because you have a lot of other responsibility in your hand. So you must try to see that they only do this all thing. You see, you cannot control who is voting, who is not voting, how it is being done because it is not provided in the law. So you keep it on them also. You must not interfere on that regard. That is my suggestion, what I would say. Vinayji has to add something on this.
Yeah, I can add to this one. But what I usually do, I provide an email to all the persons, like for the purpose of constitution of the SCC members. So this is it was rampant here earlier. So I have provided email to all the SCC members, giving details of whatever percentage is there for each and every person, and I have also given that if no one is approaching for the AR, then this person is having the highest voting percentage, then I will be considering this person as the nominee of yours. Or if you are coming up with a AR with more than this percentage, then that will be taken. So that is what I have written in the mail, and 7 days time has been given. So if some because I have also received reply from a few person that I am authorizing so and so person, or I'm myself will be the representative person. But the voting percentage of that person or the claim amount of that person was very low. So giving the outstanding detail that so much outstanding of this person is there, and if no one is coming up with more than this one, then this person will be nominated. So that will be the fair approach, I think.
Yeah, very rightly said. That is what, do not try to overdo you on your own, because that would be conducting other e-voting, which is not required as per the law from your end, right? Yes. So now you see next FAQs we have to complete. There are a lot of FAQs, so we'll try to cover as much as possible. Whether COC meeting could be conducted on Sunday and holidays, we all know there is no restriction on Sunday and holidays, and we even do on the holidays if it is within the timeline. So, but the convenience of the COC member has to be taken on account. It's FAQs is fair enough. The banks are closed on Sundays or holidays, so you must take for the purpose of maximum participation, that consideration has to be taken. whether the suspended director could be represented by their legal counsel in the COC meeting. This is a very important issue which we all face while conducting the CIRP. When a legal representative representing a particular director want to participate in the meeting. I have since day one rejected all such, claim or all such attendance by the suspended board of director. Now this FAQ also further makes it very clear that COC is akin to board of director. Now in a board of directors meeting, a director has to be present physically himself, not through an authorized representative. So a legal representative cannot be in the COC meeting representing board of directors. Except OC, yes, OC can be represented through the authorized representative because it is there in the law and regulation. Now, notice has to be given to all the suspended board, OC, and FCs, that we all know. Now, in case of section 10, basically, as we were discussing, that there are no claims after section 10 is admitted. As per the books, there are claimant. We have written to the claimant. They are not filing the claims, right? So no COC could be constituted. What should you do? So the FAQ says you must try to ascertain it from the record, send the mail to them, try to talk to them and invite a claim from them. And even after this, no claim is filed, you approach for the orders in such situation. In case of COC constituted of only related parties, FC, so in such situation, a related party FC is there, the OC can be the COC. And if there is no OC, because there is no express provision in the law for, excluding related OC. So in such situation, if it says that you may approach A for further orders in this regard. Whether the COC meeting can be conducted at the office of the creditor or bank. So it said there is no restriction and same can be conducted at the convenience of the COC. We have seen some disciplinary orders earlier wherein it said that a meeting should not be conducted in the office of the creditor, one or few orders and all. But now you see, earlier also we used to do the meeting in the place of the creditors and we continue to do it wherever is required. It saves the cost and even the convenience of the COC member or the banks. Recording of the proceedings. Now, we must be very clear on this. There is no express provision of recording a meeting, video recording a meeting, right? Now, RP can do a recording for preparation of the meeting after obtaining the consent of the member of the COC. The regulation says record the proceeding. Record does not mean that video record the proceeding. Record means that the proceeding should be recorded in the minutes, not the video recording. We generally mistake it as a video recording, but it is always better with permission. We take a video recording for preparation of the minutes, for any dispute on the discussion afterwards. So it might be beneficial. Verification, it says that it is the duty of the RP to constitute the COC within 30 days. He should verify the claim based on the available information and document. Sharing of fees. Sharing of fees, we all are very clear that who raises the invoice, the amount must be paid to them also. The interlinking sharing is not allowed. The regulation prohibits it. Right. So for success fee also, the performance link incentive is for the IP only, not for the IPE. Now, if the COC fails to approve the fees of the professional selected after due process, what are the remedies available? So remedies is definitely RP must appoint the approval of the fees before appointing a professional to avoid any confusion. This would avoid any confusion for, before appointing, you have taken an approval. And even after that, the COC is not approving, not making the payment. Yes, definitely you can approach a adjudicating authority.
Jitendra ji, is the document available on IBBI website?
Yes, it is available on the IBBI website. It is available under, you see, same homepage under FAQ.
Okay.
On the homepage, there is a FAQ tab where you can download this.
Thank you.
Can the IRP or RP liquidator appoint other RP? Yes, other IP can be appointed by the RP IRP. There is no bar that you have to appoint only IP for the support service functions. The 1% fees payable to the IBBI, it is over and above the professional fee, and it is part of the CIRP cost. It is not that you have to deduct from the professional fees, right? So you have to make the payment and form it as a part of the COC. Whether a newspaper appointment is required for the appointment of professional, there is no mandate requirement for appointment of professional in the newspaper. But that should be done in a transparent and arm's length basis in consultation with the COC. Whether L1 fee is the sole criteria for that, all depends on the COC approval and appointment. It's not, L1 is not the sole criteria. A same professional can be appointed for the various assignment. There is no bar. Now, when the COC is not incurring the expenditure, not making the payment for the CIRP expenditure, should you incur the fund from your own pocket? If you are having difficulty in arranging the fund or the interim finance, the FAQ makes it very clear that no personal fund should be deployed for conducting the CIRP. If you face any difficulty, please approach the adjudicating authority for the relief. You are not expected to incur any expenditure from your own pocket. I understand we face a lot of time a problem where the legal person are not willing to appear unless their fees are paid, valuer not giving the report, right? So we tend to make the payment from our end so that that timeline must not be disturbed. But the FAQ says you must not deploy your personal fund. Regarding the authorized representative for home buyer, so now the regulation has been modified and changed, wherein after appointment of the authorized representative, awaiting order from the adjudicating authority, the AR must continue to perform his duty, irrespective when the order is pronounced for his appointment. Now, the applicant in such cases for 12A is again for the 12A. Now it's on the same line.
One small query.
Yes, please.
Same. The AR is appointed, the AR is chosen by the home buyers or class of creditors. And RP will apply to the NCLT for the approval of the appointment.
Right.
Then same, can the fees be paid right from the date of first attending the meeting by the
Yes. If he is doing his duty, attending from the day, unless there is non-approval by the adjudicating authority, but up to that time he is eligible for the fees.
Okay. So right from the beginning of the
the
meetings, he is eligible.
Yes.
But I think it is not mentioned in the regulations. Or is it mentioned in the regulation that he can start his duties as AR without getting the confirmation from the NCLT?
No. If you see, regulation 16A2 has been amended recently.
Okay.
I think you are reading a earlier regulation.
Maybe.
Right? So earlier it was there that till he is appointed, he is not appointed. So then there used to be a delay where the order was not passed. So for this reason, this regulation was amended. Right. In case of withdrawal application, we must be aware along with the Form FA, there is requirement of bank guarantee. So can a 12A application be filed without a bank guarantee for withdrawal application? So it says no, the requirement of bank guarantee is mandatory. But in some situation, the applicant are not willing to give a bank guarantee. They say that we'll make the payment completely before filing of the application. I think, in my opinion, this FAQ does not say it, but in my opinion, that can be considered. whether the withdrawal application can be filed by the other FC who was not the applicant in case of Section 7. So there is a main applicant on basis of which the CRP is initiated. Now, if any other COC member want to file a withdrawal application under 12A, he might be having vote of more than 90%. Can he do so? There is a Supreme Court judgment in this regard. No, applicant means original applicant of the CRP process. Only he can withdraw the application who has filed it, not any other creditor, even before or prior.
But I think this should be amended.
No, I think this is a correct approach.
Because if the majority creditor, if the person holding more than 90% is not allowed to go for withdrawal, I mean, this is basically the insolvency process is for resolution process. If the more than 90% of the creditors are agreeing
but you see, but you see the applicant who has filed the application, he is not willing to withdraw it. So you cannot force. It's a process, na.
But
It's
then
gone by the law.
For a ransom. Then he is taking the.
So let us not argue. Let us not argue. We'll argue some other day on that. Okay. So let us continue with the other provisions or other FAQs. Upon filing of the 12A application, yes, he has to continue with his duty irrespective of till the order is passed for withdrawal of CRP. Control and custody of the CD asset, we have seen in many orders by the NCLAT, which direct the IRP not to constitute the COC, or the CRP may be carried on to going concern, not to issue Form G, right? So whether the RP has to discharge his duty with regard to CRP, whether his minimum fees regulation apply. So the FAQ makes it very clear the minimum fee regulation continues to apply because he is custodian of the asset of the corporate debtor, unless the entire CRP is stayed. Right? So he has to take all the steps in terms of the order of the NCLAT. If NCLAT says COC not to be constituted, fine enough. But the other duty he has to perform, like collation of the claim, public announcement, whatever is there is required to be done, he has to continue. If the NCLAT order says no action to be taken by the RP, everything stops. So it depends on case-to-case basis. Not just, you see a COC constitution has been stayed, everything is stayed.
But there have been a number of cases decided by the courts that no fees payable during this stay period.
I think you see this FAQ what says, in my opinion also, when you are allowed to continue as an RP, your name is there, minimum fee regulation must be there. Court might have ruled it otherwise, but that is, you see, up to your negotiation with the COC. Generally, we try to settle it on a lump sum basis. Definitely, we also practically understand, you see, if the process is stayed for one year, so we try to settle it on a lump sum basis, maybe for 2-3 months or so. Vinayji, your take on this?
Yeah, this is a welcome step for the IPs. And in fact, there was a confusion earlier whether the fee is payable or not. And COC member used to say that no fee is payable. So after this FAQ, it is good that if we are responsible for something, if we do not do something, then NCLT and the COC member will be behind the RP. So if we are responsible, then we must get the minimum fee. So this is and with this FAQ, it is clear to the COC members as well as the NCLT that fee is payable. So I think it is a welcome step for us.
Yeah, you can at least show this FAQ to the COC member. Look, this is what the view of IBBI is. You cannot say that my fees is not payable by showing any court orders and all, right? Now, this FAQ also clears that whether you are required to do a board meeting, the meeting of the members or not, it says that all compliances of the provision of the Companies Act is required to be done. Generally, what we do is in this regard is we consider the COC meeting as the board meeting also because board members are also invited in that meeting. Control and custody.
Here, Mr. Jitendra, small doubt on the question itself.
Yes, Ramesh, good to see you.
Yeah, thank you. Whether board meetings are required to be held by directors, the question itself seems to be relooked.
No. Question, you see, that's why you see I said that generally what should be done in this regard, the COC meeting which is being held should be treated as a board of meeting of the board of the directors. You take this, I think I have done in all my assignment in this same manner. So
No, but
board cannot convene a board meeting.
No,
That
the
is,
question is wrong. That's what I'm saying.
question is basically generally, you see what, even the wrong question has to have an answer. Na?
Right. Our answer is okay.
The question is not wrong, sir. The
Question
directors
is-
continue to be the directors of the company, though they don't have the powers.
No. The question is like whether they have to convene on their own. That's the point.
No, that they
44.
cannot. They cannot do. They cannot do. In my considered opinion, the board cannot function independently because you see, power of the board is suspended from when the CRP is commenced.
That
So
is
there
where
is
I'm
no-
just pointing out. I'm just pointing out the question is wrong.
Yeah. So the reply also is vague. Actually, you say that भाई आप देख लो company that में क्या है. You do it on your own.
ठीक है, query थोड़ा wrong है. ठीक है.
ठीक है. Right. So now this is also made very clear. Although we all are clear that can a control and custody be symbolic? So law is also very clear that there could be no scenario of symbolic control and custody. The regulation CA specifically provides that how the control and custody should be taken, and it should be taken. So there is no question of symbolic control and custody. Yes, you can do one thing. You take control and custody. If required, you can entrust a person with the control. Right? For the custody, not the control, for the custody, for the purpose of running the company as a going concern. Maybe the factory manager, maybe the general manager, maybe the employee or your employee, that can be done. But the control and custody has to be physical always and with you, with the RP. Right. Now, when there are no registered office, other place of business is not in existence, director are not reachable, how do you do all this? Is basically, we all know 19.2 and all, and seeking local assistance from the police authority, tracing office, tracing director. Even if that is not possible, the COC may recommend liquidation as per the regulation 40D. If there are no asset tangible or intangible, or seek appropriate direction. Whether the process of handover of the charge of directors to the RP needs to be video recorded. There is no explicit requirement in the law for video recording the handover process. But yes, you may do it, or maybe I would say must do it. Proper maintenance of handover record evidence will save you in future regarding, you see, the asset which has been removed prior to the CRP. So proper documentation. Now this regulation 3A, which was brought in subsequently, maybe 2 years back, clearly specify how do you take handover. There should also be a witness from your side and from the side of the suspended board. Now, if the statutory auditor or the auditor whom you are asking for the information does not provide the papers, does not provide the information, how do you do it? Whether the RP is required to file a disciplinary case action before the ICAI. The query says, yes, you can file application under section 92. If he fails to perform, fails to give the information, and yes, you can also approach the regulatory authority such as ICAI or NAFRA against such errant auditors. Whether filing of avoidance applications would be approved by the COC. There is no requirement of approval of filing of the avoidance application by the COC. It is the duty of the RP to file an application by making an opinion, independent opinion and observation on all such transactions happened prior to the CRP commencement date. So the IP can take information from the COC, from the creditors, from the auditor reports, but there is no requirement of approval. Information with them can be shared. So they may facilitate avoidance of identification of audit transaction. right? Regarding the transactions are dated more than 1 year or 2 years. So can 66 be pursued in 6 cases? The FAQ says, and we all do it. If it does not fall under 43 or other deeming section, we file it under section 66 if there is a fraud element in it.
Jitendra ji, see, in case the COC decides not to file application for perfect transactions, can the
No, you cannot hit to that request.
Okay.
You cannot and must not hit to that request. If there is a warrant transaction, you have made an observation and opinion, you must file an application, irrespective what the COC says. You record everything in the minutes and then proceed to file.
Can we ask the bankers to supply any information as relating to
Yes,
these avoidance transactions observed by them?
It is as per regulation. It is as per regulation 4. Earlier it was not there. Now this regulation was amended subsequently, wherein you can seek every information from the financial creditor, like forensic audit report, valuation report, stock audit report, everything. That will help you. We have filed many cases based on those report and details.
Because suppose if IP has ignored certain transactions and later on if bankers observe it and I think they are taking action against IP also.
You see, there is no provision as such that bank can file. No. It is only for one section. You see, preferential section. But for the other section, it is not there. So if the bank does not file even after pointed out by the RP, definitely they can approach NCLT under section 60 subsection 5 or any other section. Or maybe approach the...
They can recommend to IBBI to take action on the IP.
Yes. They are doing it or they may do it.
And whether forensic audit report is required to be submitted? Or
we are coming to the next question on that only, that whether forensic audit is mandatory or not. We are, under a dilemma whether the forensic audit at all is mandatory or whether it is a avoidance transaction audit. Let me clarify, there is no requirement in the law for doing a forensic or a transaction audit. It is a duty cast on the RP. Even if you do a forensic audit or a transaction audit, you can solely, get the help from the report. But the duty is cast on you to make an independent observation and file an application, not just based on the report. Many such application has been dismissed because the application is based solely on the report. You have not applied your mind. So this FAQ also make it clear it is not mandatory. IP may himself decide that yes, if it is an avoidance transaction, it is a fraudulent transaction. I know there are some orders which has been dismissed on this ground that no forensic audit has been conducted. But the law is very clear. There is no requirement of forensic audit or transaction audit. But as a professional, you might not be expert in unearthing all such avoidance transaction. So it's better we appoint a professional to get an insight into a detailed transaction. Because at the end of the day, whatever application you file shall be adjudicated by the adjudicating authority. And when you file an application under section 66, it's basically a fraudulent transaction. So when you say that a fraud has been conducted, the onus of proving it as per the Law of Evidence Act lies firstly on you that the fraud has been conducted. So you have to demonstrate through a primary evidence or a corroborative evidence that yes, this is a fraud. क्या हम simply एक चीज submit कर दें और बोल दें कि fraud है? That is not sufficient enough. Right? So the report helps you in unearthing the detailed and the corroborative evidence behind the transaction, which can further substantiate before the adjudicating authority. And your application might not be dismissed because the thorough verification has not been done about the transaction. Now this, this FAQ is also there, that if COC is not agreeing, right? So it also says it is a duty to file an avoidance application. In such situation, he may seek direction from the AA in this regard.
In point number 53, it says before conducting forensic audit, IP must discuss the same with COC and get COC approval for fees of such. Only for fees purpose we need to
Only
take
for fees.
the permit.
Only for, you see, whatever CRP cost is incurred has to be approved by the COC. Now you appoint a professional. The fees is not approved by the COC subsequently. So what you will do? You are liable to make the
Even-
payment to the professional you have
Even at
appointed.
that, sir, even at that stage also COC can say no. They may not
They can
approve
say-
it.
They can say no. Yes, they can say no.
And then we
But-
have to approach AA only.
There are two situations in this. You do the observation and opinion based on your own basis and file an application. No report is required, no forensic audit is required. If you are unable to do, take a direction from the AA that what to do. I feel that this transaction must be thoroughly checked and audited. So that depends on case to case basis. How do you act? And how do you convince the COC in this regard also?
I was asking one question that whether the forensic audit report is required to be shared with the COC members and directors or not.
Yes. Every reports and all must be shared with the COC members. Regarding the director, you see, when you have an observation by the forensic auditor or a transaction auditor, it is prudent enough that you share the findings with the directors. At least give them the chance of replying and answering to the observation raised. That must be done, I think.
To get their representation on their observations.
Right, and it makes your case stronger, na? That even after giving the opportunity, they have responded in this manner, not cumulatively responded, or if they have responded, you can improve your application before the adjudicating authority with more substantiating information and document. So it's always better for you that you give them the opportunity to respond, not just you file an application on your own.
See, PQ number 54. What action can be taken by RP if COC is not agreeing for application for avoidance transfer AA due to the cost of CIRP? It is the duty of the RP to file avoidance application. IP is not able to make.
He is able to make.
Not make out a case.
Is able. If IP is able to make a case out of avoidant action, he may seek direction from the AA in this regard.
That means he has to take the AA's approval for filing.
No, not required. You see, and that is what I have said. There are two options. You directly file an application if you are yourself able to make a case out of it. Auditor is not required. If you say that, no, for this transaction, I require an auditor and COC is not approving, but in your opinion, this item is avoidable transaction. So then you file with the AA. It depends on case to case basis.
No, but then what for he is required to seek direction from AA in this regard?
Yes, now if he is not approving,
because COC is not approving.
If the fees are not being approved.
Only for the fee.
If COC is not approving, can we assume that there is some collusion between COC and CD?
No, you cannot assume that, because there are situations wherein COC genuinely says, "Bhai, इसमें तो कुछ है नहीं, asset भी नहीं है, कुछ नहीं है, तो why to increase the expenditure?"
There is a possibility also, no, sir. There is the possibility of collusion also, which.
But you see, you should not apprehend on your own unless you have a document on record that there is a collusion. I mean, you must not do that on your own.
Because some disciplinary cases were there where COC and CD colluded and IP was not given some permission.
Maybe it can happen. But if you are aware, definitely, if you are aware, you must bring it on record before the adjudicating authority and clearly capturing the minutes, but not on surmise and conjectures. कि आपको लगता है कि COC और वो मिल गया और आप एक्शन ले लिए without any proof. You must not do that.
I think for the purpose of forensic audit, it is very much clear that forensic audit is not at all required mandatorily, but for the insolvency professional, I think all the responsibility of unearthing the proof transaction will come into his shoulder. So I think it is always beneficial for IT to take the forensic audit, so that whatever responsibilities are there for unearthing because in future some PUFE transaction may appear, and all the COC member will charge you that you have not conducted forensic audit, and that is the reason the so and so transaction has been surpassed, or you may become victim for that one also. So at at all level,
Sir, in case
forensic audit is required to be conducted for the safety of the insolvency professional or RP only. But I think Mr. Loya is also correct that at times the COC member want to reduce the amount of the CRP cost, and they recommend that no forensic auditor should be appointed. But it has to be seen from the purview of case to case basis, how much amount is involved and how much means PUFE transaction can be there or not. And considering all these things, some decision has to be taken by the RP, and it has to be, if any such transaction can be there, the double A NCLT should be informed of this one. And if the forensic auditor is not appointed, basic whatever region is there, all such regions should be minutized, so that in future IBBI will also ask you that why the forensic auditor was not appointed and why you have not filed PUFE transaction. So each and every point, the region given by the COC member, whatever accounting things are there in your hand, considering all those things, you have not appointed the forensic auditor, everything should be minutized. So, and it has to be approved by the COC member in the minute book.
And also to add further, I mean, the best option on your hand in such situation would be to file an application, whatever you have on hand. If you can file an application before the AA for seeking direction for approval of the fees, in that also you include that these are the awarded transaction, in my opinion. Now let the AA take a call on that. Right.
Sir, in case
Binay, tell me when to stop, because I think we have passed the maximum time.
No, you have 15 minutes. 15 minutes.
15 minutes, right? So yes, Mr. Rao.
Yeah. Actually, suppose if COC is not approving for forensic audit expenses, is it wrong if IP takes a call that he wants to go ahead with taking a forensic audit at his expense? There is nothing wrong, I think, to protect himself.
Yeah, definitely no wrong. You might do it. Nobody is stopping you from that. Nah?
Yeah.
But you must not then
interfere in that.
You must not then go and complain that you are not being paid about the fees and all.
And then that is why I can take later on, no issues. Suppose if there is a strong case,
you see,
awardable application.
Let me make it very clear that अगर आपको लगता है कि there is some transaction which are avoidance in nature, you must file an application by any way, whether be it with forensic audit, without forensic audit, or whatever manner, whether COC agrees or not agree. Because what will happen is, we have seen in many cases that afterwards, when there are a bigger fraud unearthed in the same corporate data, now this same COC member will shrug off from their responsibility.
Yeah, definitely.
They will say that yes, we have never said so, because Mr. Rao
never denied.
Mr. Rao was earlier saying there was a awarded transaction of 100 rupees. So we refused to do the audit. But if you have known that it is 100 crores, we could have never refused that audit. So they will say in this way to save their skin. So you must be very clear to save your screen and record everything in the minutes in a proper and
as he said, I think it need to be minutized, and then whatever action we can take, we have to take.
Right. Let us move forward. So how to proceed filing of the awardance application if the records are not available, books of accounts are not handed over, we do not have a tally data and the complete information about the corporate data. So is it so that we are not required to file an awardance application just because we have filed 19.2? Yes, anyone?
Pardon, sir? Hello?
So, should we not file an application only just because there is no document available? We have filed 19.2 application against the corporate data suspended board. seeking document information, nothing has been handed over. So law is very clear that you can obtain relevant information from other sources, including creditor, audit report, valuation report, stock statement, or other document. And you can, if possible, base your opinion on the basis of those documents also and file an application before the adjudicating authority. Right? Everyone is very clear on this 66 that the look back period is not there for section 66. RFRP document, there is no regulation under the CIRP regulation which says that RFRP requires approval of the COC. Right? But this, and so does this FAQ arises. Whether it is required to be get it approved. FAQ says it is better you get it approved from the COC. Right? So what is the reason? It's a key document that sets out the step in each process, the manner and purpose of interaction between the RP and the PRA, along with the timeline, and this directly impacts the CIRP. So RP prepares a draft, but it must be placed before the COC for approval. There is no regulation mandating expressly on this, but this FAQ makes it clear that you must place before the COC for its approval. If there are no books, yes.
The
If
valuation details must be kept secret even from COC.
No. Up to the date when the resolution plan is not shared with them. After that, it is mandatorily required to share the valuation report with them when the resolution plan comes and is placed before the COC for their approval or
yes. Before that, I think we need to.
Right. But there is a change in that. The fair value can even be disclosed to the PRA with the approval of the COC, not the liquidation value. So if there is no books of account, there is no reliable information available, and RP is not able to prepare the last 2 years financials. So what he is doing is not, should he prepare the IM? You will face in many cases, right? So it says that no, in absence of last 2 years or inability to prepare, not serve the sole criteria of filing liquidation. So it is not that you are not able to prepare last 2 years, you file for liquidation. It is not the sole criteria for liquidation, especially laid down in under regulation 40D. Even when books of account are not available, IPs should exhaust all means under regulation 4. Information from all quarters, diligent effort, alternative effort, provide whatever the information is there on board to the PRAs. If there are assets, there might be a resolution, whatever the fixed assets are there, but the books are not there. So there could be resolution even on basis of those assets, which are charged to the bank. But the books are not prepared for last 5, 7, 10 years. Right? Regarding the judicial direction, it is very clear, whatever may be the scenario, RP is required to comply to the judicial direction, even in case where the resolution plan is approved and NCLT issued to comply with the rainbow judgment. So what is rainbow judgment? Yes.
Sir, I have one question pertaining to the approval of the resolution plan from the COC.
Right.
In one case, what has happened? I have this just imaginary scenario that the COC, with the intention to secure a OTS from the corporate debtor, it kept it pending the approval of the resolution plan from its end.
Mr. Abhishek, is it related to the FAQ? Otherwise, we can take it offline. So I have to complete it.
It's completely related to the FAQ that COC can go against the timeline of the IBC and delay the approval of the resolution plan on its own.
No. Our COC has to approve the timelines, follow the timelines, and RP has to see that timelines are followed. Now, in the scenario, unavoidable scenario or in the exceptional scenario, there are cases where no decision could be taken on the approval of the resolution plan. In such cases, it is advisable you approach the adjudicating authority. COC on its own cannot extend the timeline. You have to complete the CIRP by 180 days or 270 days. Unless there is an exclusion, extension also cannot be given more than once. Let us be very clear. Although NCLTs are giving extension nowadays on an application, but as an RP, you must not seek extension more than once as per the law. You can seek an exclusion where there is a litigation, where there was exceptional situation which has avoided CRP to be completed within a defined period of time, but not the extension. And COC cannot on its own extend the period, cannot delay the timeline.
But what if the COC during the COC meeting has put the point that the resolution plan is put up for the voting, but it's not approving the resolution plan for more than 180 days? Then in that case, what the RP shall do?
You approach the adjudicating authority, inform them that, look, the period is over, the COC is not approving. You give me the direction.
But COC is giving.
You place it before liquidation if they are not approving the resolution plan.
But
you see, you cannot go beyond the timeline.
Yeah, Mr. Sinha, I can reply to this one. Let's say one plan is there and the deliberation was there on the approval or non-approval of the plan. At times, the banker takes much larger time than whatever is required. Say 270 days have expired and they have not decided on the plan. So you can always write a mail to the COC members before at least 10 days before completion of the time period, that if you are not approving the plan within 270 days within so and so time, then it will automatically be going to the liquidation. So we will be approaching we will be filing petition for the liquidation. So it is up to you whether you get it approved or not. So you just maintain your timeline. Whatever IBC guidelines are there, you just follow the IBC code. And once
I
you give
completely agree with your point, sir.
once you give this email, whoever banker is there, they will of course they will make it sure that the plan is approved within that time. I have faced a few cases in my I think in my career. So I have given this email only, and after receiving the mail within 2-3 days, they have approved the thing.
I completely understand your point, sir. But COC in the most of the time has abused its commercial wisdom. And what has
I think we can move
happens?
ahead now.
We can, yeah, we have the limited time.
Resolution. Let us go forward with the next FAQ.
Sure.
I don't think I'll be able to cover up the liquidation FAQ in this scenario.
No, not an issue. You have to complete within 2-3 minutes, I think.
Whether a resolution plan not complying with the section 32B, another provision of the code is required to be placed for COC decision. Now, this is very clear that all resolution plan along with the non-compliant plan must be placed before the COC, along with the observation that how it is non-compliant. And the section makes it very clear that only the compliant plan must be voted upon, not the non-compliant plan. ऐसा नहीं कि आपने नॉन कंप्लायंट प्लान को सीओसी के पास भेजा ही नहीं एंड अपने एंड से ही आप यू कीप इट ऑन योर ओन. दैट कैन नॉट बी डन. If there is stay in formation of COC but a order for continuation of all other CA, how should IRP and RP function? I think we discussed on that. What are the remedies available to IRP and RP to recover approved remuneration? We discussed. नहीं देते हैं तो ये पास जाओ, nothing more to be done. So accepting remuneration below 1 lakh rupees as prescribed by the IBBI and a regulation can it be done in violation of regulation 34B. It says a minimum fees prescribed shall be decided by the applicant or the COC. And this is a minimum fees. So compliance has to be maintained at all the time. You cannot accept an assignment below the minimum fees. If CD has no asset, no bank balance, no operation, no employee, no creditor, filing their claim, then who decide and pay the remuneration of the IRP and I? The applicant. Na? In such case, one person is there always, who will always be available, the applicant. अगर COC नहीं है, कोई नहीं है, तो applicant को पकड़ो. तुमने application file की है, you have to make payment of everything. If CD has no operation, no cash flow, only related party FCs are there in claimant who cannot form FC, then who will approve RP fees? Can it be government claimant? Yes, the regulation clearly says that if there are all related FCs, the OC, 16 top OC will be the COC member. In those cases, this OC will constitute the approving authority for all such cases, for everything, for every process. Whether RP is required to work without receiving monthly remuneration, which has been approved by the COC, in situation like when no funds are available with the CD, assets and books of account are not handed over to RP, assets are insufficient, RP should seek contribution from the COC if there is no fund available in the CD. If COC does not contribute, you approach the adjudicating authority for suitable direction. You are not expected to work without remuneration. Resignation, you see, generally a RP cannot resign. So the FAQ clearly reiterates the same. The RP can resign in terms of the process prescribed under the code and regulation. So I will also not deal into that, under what situation an RP can resign. You have to still decide yourself on this. Binayji want to say something on resignation of the RP? Maybe.
We have just 2 minutes to sum up, I think.
Yeah, 2 minutes to sum up. So just last, I think, yes, last one. The monitoring and implementation of the resolution plan. This is basically FAQ for CIRP process. We are not discussing liquidation today. So before full implementation, that is before full payment by the credit to the creditor by the SRA, where SRA can take over the CD and run it. So there is no harm in it. When it depends on how your resolution plan is worded. There are resolution plan which says that the operation, the control will not been handed over till the full payment is done. The operation will be done by the monitoring committee. So that will be followed. If there is a resolution plan which says that after the upfront payment, you will be allowed to run the company as a going concern under the supervision of the monitoring committee, then that will be governed. So there is no fixed rule for that. Yes, they can be handed over. The director can be appointed and they can be allowed. But under the supervision of monitoring committee, that is a mandatory requirement of the code and should be contained in the resolution plan. Is it mandatory for the SRA to nominate RP as a member of the monitoring committee? I think regulation is very clear on this, that it is not mandatory for the SRA to nominate the RP. He can choose any other member. He can even exclude the resolution professional from being the member of the monitoring committee under regulation 38(4)(b). Right. So anyone can be, he can keep any other resolution professional to be the monitoring committee member or chairman, can be decided by the monitoring committee. The monitoring committee constitution can be decided in the resolution plan, and as approved by COC, there can be 1 member from the FC, 2 members from the FC, or 2 members from the SRA. So whatever can be the constitution, that will depend what is the content of the resolution plan. Whether minimum fee criteria is applicable during the period of monitoring and implementation of the resolution plan. We all must be very clear on this, that CIRP period ends with the order for approval of the resolution plan. The moratorium under section 14 ends, so does the CIRP period ends with the approval of the resolution plan. So whatever happens after that, it is out of the CIRP period. Whatever the cost is not part of the CIRP cost. It may be the interim management cost to be borne by the monitoring committee as defined in the resolution plan. But generally, you see the onus lie on the successful resolution applicant after the approval of the resolution plan. So any fees which has to be negotiated, which has to be paid by the monitoring committee, and generally it is the successful resolution applicant. So I think that's it for the CIRP FAQ. So I think with this, let me hand it over to Binay for taking it
Thank you.
forward as per the.
Thank you. We have raised the question and answer session during the course of the deliberation only, and it was a very interactive session. And I must congratulate you that you have replied each and every question which was raised during the course of deliberation. Since we have limited time and we could not conclude each and every aspect related to FAQ, particularly liquidation aspect, but the major aspect was covering the earlier up to this CRP period only. So all those FAQ were not only FAQ were discussed, but also the judgments and what action have to be taken, what is the practical difficulties being faced by the IP, and what is the solution for facing this difficulty have been mentioned by Loyaji. So we must thank him that within this short period of time, he was in a position to deliberate in such a nice way. Now hand it over to.
Yes, I would also like to thank you. I mean, I suggested the topic because I wanted to also go through the each and every aspect of FAQ because it affects our, you see, the process also, and we become more informed that how do you, or whether something you have been doing it up till now, is it correct in the view of IBBI also. So I think thank you, IPNet, for inviting me. Yes, over to you.
Thank you so much, sir. And we would like to now first announce our next week's webinar, which is a physical first webinar of IPNet. It is my pleasure to announce that IPNet will be holding its first IBC conclave in association with IIIPI CMAI on 1st November 2025 at India Habitat Center, New Delhi. We look forward to your active participation and meet you all in person. I hope all of you all have registered, and we're looking forward to seeing each and every one of you. Now, I request Sandeep sir to kindly express our gratitude and award mementos to both our speaker and our moderator. We'll start with Lohiya ji. I'll just display the memento, please.
Sure. Appreciate for taking time and deliberating a wonderful session, sir, and accepting our invite. On behalf of IPNet community, I would like to thank you and accept this small token of appreciation on our behalf. The same shall be delivered to your office shortly. Thank you so much, Binay sir, for accepting our invite over a very short span of time. We understand the limitation of time, and it was discussed at a very short span of time. So thank you so much for accepting our invitation and totally moderated the session so willfully. Please accept our small token of appreciation, and the same shall be delivered to your office by early next week. Thank you so much, sir.
Thank you.
Thank you all.
Thank you so much. And now I request IP Tavindra Pal Singh Arora sir to kindly give our vote of thanks. Sir, you're on mute, sir.
Good evening, everyone. It is my honor to deliver the vote of thanks on behalf of the organizing committee and all members of IPNet. As we come to the close of this inspiring and enriching webinar, I would like to express my deepest gratitude to all who have made it possible. First, heartfelt thanks to our distinguished speaker, Mr. Jitendra Lohiya, and our moderator, Mr. Binay Singhania. Your presentations were illuminating, your insights profound, and the experiences you shared will stay with us far beyond this evening. A special note of appreciation to Mr. Ashish Makhija, President of IPNet. Your leadership and dedication continue to guide our community forward. Thank you to Mr. Binay Singhania, moderator, for steering the question answer session so skillfully and bringing clarity to our discussion. to Ms. Tina Saraswat Pandey, our anchor. Your warmth, grace, and professionalism have truly elevated the session. We are deeply grateful to the transition team and all our technical support staff for ensuring that everything from sound, visuals to connectivity worked flawlessly behind the scenes. To every participant here, your engagement, questions, and presence have given life and energy to this webinar. Your involvement is what makes IPNet's mission meaningful. Today's event has reinforced that when knowledge, wellness, and professional commitment come together, stronger minds lead to better resolutions. Thank you all once again. We look forward to meeting you at our next IPNet webinar. Until then, stay inspired, stay strong, and keep learning. Thank you very